ginagawa or something. So maganda na mataas yung standard natin ulit. Kagaya nung impeachment, sabi natin, pataas lang dapat ng pataas yung standard natin for our justices. Nakikita natin na ngayon, kasama na yung taong bayan sa pagtingin kung talaga bang mataas yung standard na maaabot ng mga susunod na Chief Justice.
Aside from the basic requirements of Philippine citizenship, practice of law for 15 years, meron tayong syempre requirements na character-related, integrity, probity, independence. Kontento ka ba or masaya ka ba dun sa mga kalidad ng tanong ng ating JBC panelists para makuha nga yung mga character requirements?
Sa totoo lang po, siguro dahil una pa lang tong nakikita natin, hindi ko alam kung I think there's room for improvement for the questions. Marami po nagsasabi sa Twitter, for example, na sana tumaas pa yung kalidad ng mga tanong kasi parang ang gagaling yung mga sumasagot eh. So nakakahiya naman ko yung mga tanong masyadong... Kasi for me naman, kakaiba lang na for certain candidates, iba-iba yung tanong. Tapos yung iba mas pointed, yung iba mas personal. So hindi ko alam kung kailangan ba may same standard of questions for everybody. Pero sa tingin ko, dahil first time pa lang naman to, okay na rin. Naririnig lahat ng mga points of view.
Yung sa oras dedicated for each, you think most of them got about an hour? Sapat ba yun o gusto nyong pahabain pa? Dahil mukhang nagmamadali tayo, pwede pa kaya nating extend ng konti para makilala even more?
I think okay lang din na may limit kasi this could go on eh. When you know naman, when you interview somebody for office, talagang the more sana, pero marami rin nag-a-apply eh. So okay na rin yung isang oras.
Ayan na po, nakikita natin Professor Carl, ating mga kababayan, na umuupo na po ang mga members ng JBC. Ulitin ko po ang kanilang mga pangalan. From the Academe, Honorable Jose Mejia. From the retired Justices of the Supreme Court, Honorable Jose Regino Hermosissima.
National Anthem and the Supreme Court Hymn.
Okay, panoorin po natin itong
Let us all place ourselves
kaganapan.
in the presence of the Lord. Lord God, King of heaven and earth, we lift up to you once again our affairs for today. Direct the minds and bodies of the presiding officer, the members and the staff of the Judicial and Bar Council, so that their work here will always find its origin in you, and through you reach completion. Fill all nominees with truth, peace, and courage. Remind them, O Lord, that to serve you and your people is both truly a privilege and an obligation. May this experience bring them closer to you and their families, and may their lives be now and always a testimony of your saving grace and mercy. We pray for the media. May they always be grateful to you because we live in a nation with free speech and free press. Renew in them their commitment to truth, accuracy, integrity as they participate in this process. Finally, Lord, we pray for our President. Bless him with the purest desire to know and do your will. Inspire him to carefully weigh everything and to seek your divine help in making the right decision. All this we pray. Amen.
Bayang magiliw, pero sa silanganan, alam ng puso, sa titik mo'y buhay. Lupang hinirang, duyan ka ng magiting, sa manlulupit, di ka pagsisisi.
session is open.
Good morning to everyone. The public interview on candidates for the position of Chief Justice of the Supreme Court is hereby resumed. The candidates to be interviewed this morning are the following: Associate Justice Roberto A. Abad of the Supreme Court, Attorney Rafael A. Morales, Partner, CSIP Salazar Hernandez and Gatmaytan, Professor Raul C. Pangalanan of the University of the Philippines and Chairman Bantay Katarungan. That's all. May we request Justice Roberto A. Abad to remain for the interview, while Attorney Morales and Professor Pangalanan to please proceed to the holding area while we conduct the interview on Associate Justice Roberto Abad.
Ready, Justice Robert? Attorney Cayusa will first ask the questions.
Thank you, Justice Peralta. Good morning, Justice Abad. During the recent IBP forum, you mentioned the judicial reforms, and you also made mention of one which is currently in implementation, the guidelines for litigation in Quezon City. Where did you draw the inspiration for these proposals, Justice?
You may.
What inspired me is that I'm so unhappy with case congestions and delay in our courts. I've appeared in our courts for, I think, the last 40 years, 11 years with the OSJ and then private practice for 22 years. And I'm really amazed that the crisis in our courts had not been addressed. I was really working also on this kind of reforms when this was presented to me by the Quezon City on their own initiatives, because they thought that I would be the one to advocate it in the court and bank. And I did. Although it was delayed a little because some of our members are somewhat cynical over some provisions, but I prevailed over them to have it approved. And I understand it's working well. Thank you.
Justice, would you care to tell us, to summarize briefly, what these guidelines are all about and what is the purpose and how you managed to get the court to boldly implement them, at least on a pilot basis in Quezon City?
The main things about the new guideline is that it dispenses with direct examination, and all direct examinations are taken out or replaced by judicial affidavits. So that shortens proceedings a great deal. That's the main thing there. And the others are lesser postponements. You're given a quota when you cannot postpone anymore, extensions, and then pleadings have to be a certain number of pages. And I really admire the judges and the lawyers in Quezon City for having put together this. Now, when I advocated it with the Supreme Court, in our court, I beg the pardon of Justice Peralta, but we were somewhat a very conservative court. And we tend to examine a lot of things, and it was a little delayed, and it was really, we really had a problem. So what I did, I told the court, we will hold one day, and you all come together, those who have any objections or comment, and we'll sit down. Well, two of them came, and then we discussed these things and made adjustments. And then when they presented it finally, there were other justices who also wanted later more time. But I said, these reforms cannot take place. This is our attitude. I'm withdrawing it already. I withdraw this proposal already. It's an embarrassment for us. And they approve it. You know, the court approved it because I really put my foot down there already.
This was implemented sometime in April this year. And what has been the feedback so far?
Well, I think they're doing very well. Huh? Some lawyers complained at the beginning, but they've gotten used to it. They're adjusting to it. They complain now of the judges that they have too many cases submitted for decision in Quezon City.
Do you feel, Justices, this is something that can be implemented nationwide in all the courts?
Well, Justice Carpio and I were talking the other day. I have another plan, no? Because actually I'm for just from abandoning the adversarial system that we have today, because that's very slow. It's a small funnel. Well, all the cases have to pass through this American system and adopt a combined adversarial and inquisitorial system pattern from successful European models. We're the only country who's doing this system that has taken us a long time. So I'm doing that also. So what we agreed with Justice Carpio is that we will do it in 2 phases. Maybe next week or within this month or next month, we will already come out with a resolution implementing these affidavits, judicial affidavits for all cases. In criminal cases where the penalty is not less than prison correctional or less and lesser, then it will be by judicial affidavits. But of course, I have my own, what they call that, advocacy. My advocacy is that all cases should be heard in one sitting, one face-to-face hearing with the judgment rendered at the end of the day. In common, in ordinary cases. Of course, there are extraordinary cases. Because if we follow the current system that we have, they tell me this Maguindanao massacre will take us 20 years to finish. If we follow this new system that I'm advocating, I think we can finish it in 6 months.
What are refinements that at this point in the implementation of the reform that you are advocating for have to be made, the refinements in those guidelines, so that it may be applicable to the courts nationwide?
Oh, yes. It will apply already. It will be, well, as you know, procedural laws apply prospectively to the pending cases. If it is pending, then it will also apply. Whatever they have covered, then it will apply.
Moving on, Justice. You came from the private sector before you joined the court in 2009, and you also came from the academe. And there is a story, and confirm if this is true or not, that the day before you were appointed, you actually went to court to appear, and you had an unpleasant experience with a judge. So I don't know if it's truth or fiction, but if there is truth to this story, what did you learn from that experience, and how has that affected your perception and how you deal with lower court judges?
Well, it's really fiction. Although I really had run-in with the judge. I forgot the name of the judge already, but she's an honest judge, by the way. Except that she is, what they call, I think she is ill. They say that she is ill. And she had a short temper. And I was presenting a witness, and he was telling me that, what they call that, I did not prepare for my cases. And that's not true. No? She somewhat insulted me, and I forgot already what it was. But I told him that she has no right to insult me. That's what I told him. I told her, because I prepared for my cases. So after that, well, I told her I am going to file for inhibition because of that. But later on, a friend of mine, just Elvira Panganiban or something in Quezon City, called me up. He said, best friend, told me about it. And so he said, I don't plan to file any case against her because she's an honest judge. That's not something I'm going to do to an honest judge. But I said that it's just a misunderstanding between us, and that's not my purpose. I can understand she has problems. That's it. No? That's, although by coincidence, I became Associate Justice, and then she got sick, I understand. So, but before she got sick, we somewhat reconciled through Justice Panganiban.
Thank you, Justice. Now, coming from the outside, as they say, prior to your appointment to the High Court, how important is it to you today that an insider is appointed to the position of Chief Justice?
Well, if a candidate has what it takes to be a Chief Justice, he can be an outsider or an insider. But I have, of course, a natural bias for the insiders, because the insiders are tested. Their performance are on the record. You can look at it, and then you can listen to people and see what they have done. But if the president appoints an untested outsider who will serve for 18 to 20 years, you take a lot of risk. If later on he turns out to be mediocre, show-off, lazy, ineffective, well, he has to commit an impeachable offense to get him out. And you would have then bound the country to a Chief Justice for 20 years. So maybe it's not... so that's why I have a bias for insiders in that way. Not necessarily myself.
In contrast, what can a Chief Justice achieve in 2 years?
Well, I think a lot. For example, the reforms that I'm working on can take place in 2 years, and these are substantial reforms, like changing the system for hearing cases and decongesting the jails. I mean, also in a committee where we are working to decongest the jails and reduce the population into 1/2 in the next 2 years. And the rest, Your Honor, I'll sow the seed that may be reaped by the future.
Thank you, Justice. You chose not to inhibit yourself from acting on the petition filed by Solicitor General Frank Chavez on the composition of the JBC. The reason being, and I quote, you found no compelling reason to do so. End of quote. In what cases did you feel compelled to inhibit yourself from participating, and why?
Well, when I feel I have a bias that I could not control or something like that, huh? Then I'm going to inhibit myself. And those compulsory inhibition that we have, or I've been approached, sometimes I'm going to inhibit myself.
I have one final question, Justice, but before that, may I just express the thanks of the IBP for always trying to innovate and for consulting with the members of the bar before you decide to implement something, and I hope that will continue in the Abad Court. My final question, Justice, is do you have any specific experience with respect to having to make a decision which may have been unpopular to the appointing power and that may have shown your integrity and independence from that appointing power? Could be as an associate justice.
Well, I was appointed by President Gloria Macapagal Arroyo. And when the Truth Commission case came up, I voted for the Truth Commission because my reasoning is that you can go no wrong looking for the truth. So I can take a position adverse to the one who appoints me.
Thank you, Justice Aban. Thank you, Mr. Chairman. I have no further questions.
Attorney Mejia.
Thank you, Justice Peralta. Good morning po, Justice
Good morning.
Aban. How will you assess your performance as an associate justice thus far?
I don't know. I've never really sat down to assess my performance, but from the record, I think I have one of the lowest, what they call that, pending records. The judicial cases, which is the one that we really matter, because some of the administrative cases, they're in our docket, but they are really being heard by the JBC and other agencies, so we could not act on them. But on the judicial cases, I think I have only 314 or something. I'm not sure, but it's in your record, Your Honor. And that's not, I think that's one of the lightest in the court.
Si Senator Sagisag po nominated you, no? And in his nomination, he pointed out that the reason for him nominating you is that we need a transitional Chief Justice like you that would provide if I may use his term, a calming effect. How will you provide po that calming effect in the Supreme Court as Chief Justice?
We have a wounded court today. After the impeachment trial, well, we have a problem that we thought, well, we somewhat taken aback by this development and discouraged most of us. The way I look at it is that if I become Chief Justice, the first thing to do is to forgive. Because you cannot have, what do you call that? You cannot have what do you call the healing unless there's forgiveness. I hope the President will forgive us also and will forgive the legislature and we can reconcile. That's the first thing I believe that how I'm going to start it if I become Chief Justice. Can I just get a thing?
So Justice, but if seniority po is a concern for the so-called outsiders, it should also be a concern for someone like you who is less senior in rank. How would you address that concern po?
Well, I think, I was nominated, not actually seek to be appointed Chief Justice, but I had to honor those who nominated me, and then I believe that with God's blessings, I can do it. And actually, what we're offering is service, to be a servant of all, and that's not, it's not really as if being a Chief Justice, makes you a better person. No, it's really a job that you have to do. So I think my colleagues are going to understand that. And I can say that, from Justice Peralta, maybe I can tell you, that I work very well with our court. As a matter of fact, in the last 100 years, there has been no internal rules of the court. And asked the Chief Justice to prepare one. He made me a member of that committee, and we had done internal rules. I am proud to say that I think I prepared the working draft of these internal rules. And then, when the chairman Natura vacated the post, they chose me to head the internal rules when there were 4 senior justices in the same committee. When we put up so that shows some kind of trust. So when we established the ethics committee that will investigate all complaints against the justices of the Supreme Court, and we had a secret voting, and we elected 4. I was elected into the ethics committee to investigate my own peers. So that is trust. And I think that is what we need, that's what a Chief Justice needs, not a sense of, what do you call that, academic superiority, but trust is important.
Kahapon po na itanong kay Attorney Ligarda tungkol dun sa divorce, no? At if I remember correctly, she made reference to the somewhat influence of the Catholic Church in the position of the legislative body in passing a law for divorce. No? May I ask you po, what principles should guide the separation of church and state?
Well, the classic answer there is that they should not get too entangled too closely to each other. Well, the Philippines, unlike the United States, the Philippines is somewhat more spiritual or religious, in a sense of we have prayers said in school and we have even catechism in the schools. So there's some tolerance for religious practice in the Philippines. As a matter of fact, we have Mass in the Supreme Court on Fridays. And I think it's a healthy tolerance because in one decision it says that religion is important also for keeping the morale of the population of the country. But I'm, of course, against religious personalities, what they call that, trying to influence political decisions. I'm against that.
you were talking earlier about adversarial inquisitorial system. Mayroon pong nagtatanong no sa text at saka sa ewan ko kung sa Twitter. Siguro linawin lang po natin siguro sa publiko yung marami kasing nabibighani sa panonood ng Law and Order, pagbabasa ng John Grisham, marami pong nabibighani sa konsepto ng jury system.
Sige.
Ano po ang palagay ninyo doon?
Yung jury system, mahirap lang tayong bansa, no? So, yung jury system, magastos yun. I-hotel mo yung jury. Wala nga tayong pansweldong mabuti para sa judges natin. And then, ang jury system, 90% of jury trials take place only in the United States. The rest of the world no longer practices jury trial, no? Except a few in Great Britain. See? Ngayon, what I am proposing is that to abandon the adversarial system. Pwede bang paliwanag ko lang itong adversarial system? Yung adversarial system, binigay sa atin ng mga Amerikano, mga 100 taon na nakakaraan. Dito sa adversarial system na ito, ang pinaglalaban ang nagdedemanda at ang idinedemanda. Ang ebidensya na padidinig sa judge, yung gusto ng abogado. No? Hindi yung gustong malaman ng judge para ma-decide niya yung kaso. No? Kaya nga, dahil doon, ang abogado pwede niyang habaan, i-delay ang kaso kasi siya ang nagdidikta kung ano ang ebidensyang pakikinggan ng judge. Yan ang ating adversarial. Second, hiniram natin ang batas ng Amerika, ang rules ng Amerika sa trial procedure. And do you know that those rules were designed for both jury trial and bench trial? Kung kaya nga dito sa atin, maski wala tayong jury, pag nagbibista tayo, parang may jury. Bakit? Yung judge natin, pag merong objection, ini-screen pa niya yung tanong. Sa Amerika, ini-screen yung tanong para yung barbero, farmers, wag nilang madinig yung inadmissible evidence, yung evidence na palso. Wag nilang madinig. Pero dito sa atin, wala tayong jury. Ang nagdi-decide ng kaso, yung judge din. So, ang ridiculous na nangyayari, yung judge, ini-screen niya yung tanong para madinig niya yung lang admissible evidence. That's really ridiculous, ano? Secondly, sa jury trial, yung member ng jury, dapat wala siyang alam sa kaso. Diba? Hindi niya nabasa ng document, wala siyang opinion. Ideally. Kaya nga, pagpresenta ng ebidensya ng plaintiff at ng defendant, uumpisahan niya from the beginning to the end. Kaya at sa inyo, ng mga judges dati at saka mga practitioners, ano nangyayari? Tatanungin nung interpreter yung plaintiff's witness. Halimbawa, nagbenta siya ng motorsiklo, let us say, for 250,000. Hindi nagbayad, 30 days credit. Idinimanda niya. Hindi sila nagkasundo sa stipulation of facts sa kaso. Ang gagawin, iprepresenta niya yung plaintiff. Anong tatanong ng abogado? Do you know the defendant in this case? 99% ng mga witness natin hindi magtitestigo ng English. Gusto nila Filipino. So, merong interpreter. So, do you know the defendant in this case? Nakikilala mo ba nasa saktol sa kasong ito? Opo. Yes, sir. Why do you know him? Bakit mo siya nakikilala? Nagbenta ko kasi ako sa kanya ng motorsiklo, sir. Because, sir, I sold motorcycle to him. And then, when did this take place? Where did this take place? Who were present? If I show you a copy of the sales invoice that you mentioned, will you be able to recognize it? Showing to you the sales invoice. What relation does it have to the sales invoice that you mentioned? Anong relasyon ito? Parang kamag-anak, hindi yung magkamag-anak yan. So anyway, yes. And then, I would like to ask that the sales invoice be marked as our Exhibit A. So, matagal, Exhibit A. I would like to ask the name of the buyer be bracketed, marked Exhibit A-1. The name of the article bracketed, marked Exhibit A-2. The name of the price of the article be bracketed, marked Exhibit A-3. The name of the buyer, signature of the buyer, be bracketed, marked Exhibit A-4. You know, so it takes a long time. When the dependence time comes, ganun din naman. State your name and other... Because our rules is designed for a jury trial where the jury knows nothing about the case. But that's not true in our situation. We have a judge who has seen the pleadings, who has seen the affidavits attached in the criminal case, who knows what the case is about. Judges tell me, when I go there, because I've been going around the country, tell me that when they see especially in ordinary cases, when they see the complaint, and when they see the answer and the annexes, they already know who will win the case. Yet it takes 3 to 5 years to decide that case because the judge has no control over the proceedings. It is the lawyers who dictate what evidence is going to hear. Dapat pwede nilang sabihin ng judge, teka muna, ang problema dito kung nagbayad o hindi. Ano bang ebidensya mo na nagbayad siya sa'yo? Your Honor, ito, meron siyang invoice dito. Oy, meron siyang invoice. Hindi ka pa raw bayad. Your Honor, bayad na ho yan. Ito ang check yung pinagbayad ko. Tingnan ko nga. Ay, meron siyang check eh. Bayad ka na raw. Your Honor, yan hong checking yan para sa ibang transaction. Para dito yan. Oh, oy, ibang transaction daw to. Hindi ho, yun yung transaction na yan. Meron pa ba kayong ebidensya? Wala na ho. Eh di, in a few minutes, the judge can decide the case. But you know, here, it will take 3 to 5 years to finish this case. Mag-a-appeal pa. So, in place of that, we are proposing a combined adversarial and inquisitorial system. What is the inquisitorial system? The inquisitorial system is actually the God's gift given to us on settling cases. When you go home, your children quarrel, 2 of them. What do? Well, do you say, oh, I will ask you to explain it first. Explain your side, argue it, you tell me your story. And then, that's how he begins. After 5 minutes, you say, reset, call again 3 months. No? Postpone 3 months. Oh, that's not the case. A true dispenser of justice is going to ask the questions that he needs to decide the case. Ask them. That's what we do. And you know, some children are articulate and some are not. It's the same case in our courts. Some lawyers are better than other lawyers. Some questions that are important for making a decision are not asked. And the judge in this process will be able to ask. So what do we propose? We propose a one-time hearing where all the parties will be present. This is something that is being done already. You know? I'm not reinventing the wheel. I don't claim credit for this kind of system. The lawyers, the parties, the witnesses come together in some kind of a round table, and then the judge presides over it. He swears all the witnesses at the same time. All right? And the judge starts to ask questions, with questions shifting from one witness to the other. That is an authentic confrontation. See? And then the lawyers, this is the adversarial side, the lawyers are free to conduct cross-examinations of the witnesses. In ordinary cases, this will be done in a GP. And then the judge, on the same occasion, will make his decision. And do you know the advantage of that? The judge making his decision at the same time. He has the clearest picture of the case. Second, the public that listens to the witnesses as they testify will be observing the judge. And if it appears that one party is really lying, the judge will be deterred from saying, this party wins. That's precisely the value of public trial. But in our present system, they hardly meet. You present the plaintiff today, 1/4 of his testimony. After 4 months, 1/4. 4 months, 1/4. Later on, up to about cross-examination, etc. The plaintiff and the defendant will never meet. But here you will see the nuances of the speech. The Bible says that conversation reveals the man. And that's the thing that... thank you very much for that question.
Maraming salamat po. Yun na po yung huling katanungan ko. Salamat po, Justice Peralta.
Justice Lagman.
Thank you very much, Mr. Chair. Justice Abad, good morning.
Good morning, ma'am.
You are known to be an innovator in the Supreme Court. In the 3 years that you have been sitting as an associate justice, what have you done to declog the docket of the court,
The Supreme Court
the
itself.
Supreme Court itself?
Well, we prepared the internal rules that somewhat define some of the problems that we have there. But let me tell you that the Supreme Court's docket is not necessarily clogged.
Yeah.
The Supreme Court is the best performer in appellate courts.
Okay.
About, I think I would admire the previous justice because they changed the system so that we're able to dispose of our cases better than before. As a matter of fact, we're now eroding very quickly the past. You say that we have problems because we really have old cases that have not been decided.
Yes, that's it.
But you should look at how we dispose of new cases and how we decide them. I think we are doing it very efficiently, although it stands to be, what they call that, further enhanced.
I think the problem is with the old cases which have been pending with the court for a long period.
Well, we have an agreement. I think the justices are complying with it, where we are now eroding on those old cases. I think that's really a shame that we have those cases. We know, no, we ourselves are embarrassed by those things, so we will work on it.
I see.
Thank you very much.
It's nice to hear that you're working on it. Okay. Now, you talked about impeachment also a while ago. In your opinion, did the impeachment of the former Chief Justice infringe on judicial independence?
Well, not really, not infringe.
Yeah.
No, I don't think so because
What
that's
is your
really
opinion on that?
that's really their function. Well, although the case is over, so now we can comment on it because I don't think there's any pending thing with us. What I did not agree with there is that the way the complaints were filed, the preparation of the complaint, I think was really hurriedly done and it was not somewhat indecent way. So I disagreed with that, and I think I joined the court in that kind of step. But I think that's past already.
Yes.
And I think as I said, we should
You have to move
forward.
Yeah, but we also want to know your thoughts
Well,
about
that's
it.
my
Because you mentioned about
I'll stand
impeachment.
by that idea, by that position.
Okay. You were with the academe before, and you were the chairman of the bar examinations
Yes, Your Honor.
last year. Now, annually, only at least 30% of the examinees pass the bar examinations. What do you think, Justice? Is this an indication of the low quality of legal education in our country?
Well, yes, I think so. I agree that. Now we're trying to do something about that also. Although that's now within within the jurisdiction of the Legal Education Board.
Yes.
But we're working with the Legal Education Board to try to improve legal education in the country. Actually, what I've been suggesting, to go hard on schools to improve themselves.
Yes.
But I know that the key component of a judicial system is the lawyer. And so we have to raise the standards for admissions of lawyers. And what is more, I was suggesting, and we're studying it in our committee, to limit the bar examinations to 4 subjects only. For example, civil law,
What are the subjects?
remedial law, political law, and criminal law. The really basic subjects that beginning practitioners need to be able to go into private practice.
Okay.
In order to free more units for developing specific careers for lawyers. For instance, they can, like Ateneo is beginning to do it now because of my suggestion with SEDPRE.
Yes.
We're trying to work out where the academe will develop those who want to become judges
Yes.
and develop their sensibilities for being judges, their values, as well as their ability to dispose of cases. And some who will be litigators, and then some who will go into commercial practice. So that first year and second year may be devoted to studying the basics. So, Anyway, when you become a lawyer and you work with a law office and you start to practice, that's the time you look into specialized laws like intellectual property. You don't need to pass the bar, no intellectual property to pass the bar. That's not the point, really. Well, in all countries, they don't have an exam like us where we cover all the laws. They only cover the really major subjects. That's why I said, our curriculum is so crowded that the students just learn the law, but not the practice of the law. I think that's what reform that we are looking at, Your Honor.
Okay. Now, so aside from activating the Legal Education Board, which I think they're just starting to take off, no? If you will be fortunate to be nominated and appointed as the next Chief Justice, how do you intend to regulate these law schools, aside from what you have stated?
Well, I have no, even if I become Chief Justice, I will have no power to close down these schools. But, well, I will invite I certainly would invite all the deans and maybe talk in schools, go there again, I visited them, and then ask them to, well, see their problem. No? What is their problem? Why is it that their students are not performing very well? We have to investigate the causes. It does not work sometimes that you just say you close them down. No? Sometimes you have to see, why is it not working for them? Why is it working for other schools? I will encourage such kind of conversation.
Okay. In relation to this, there is a question from our Twitter, Justice, and I will read it. How do you respond to criticisms that your bar reforms, namely MCQs, will produce lawyers who are good at guessing but can't argue?
My new MCQ?
MCQs. MCQ.
Well, my answer to that is this. Multiple choice questions is a tested measuring stick.
Yeah.
No? It is not as if we are inventing it. The whole world, there's no professional regulation authority in the world that does not use multiple choice.
Okay.
Because it's really, what do you call that? It's really time tested. Do you know that multiple choice, in a sense, asking these questions in a sense is you cannot really, let us see, when you teach law, I don't know if some of you have taught law, you teach a subject, let us say evidence, when the finals come, how many questions do you ask? 10 questions, problem questions.
Okay.
So if they can answer 80% of those problem questions, even if you taught them 1,000 principles and evidence, your assumption is that they know 80% of your of that 1,000.
Okay.
So in a sense, it is statistics, no? Sampling, taking the sample from the mind of the students. So multiple choice is good because you ask 100 questions and the answers are exact. It is good for sampling.
Okay.
If you ask 100 questions in a subject, you can be certain, scientifically, they say, with 3% error, that you are able to test the percentage of knowledge that the person has on the subject. That's why we adapted it.
Okay. So,
By the way, I'm sorry.
Okay.
But we also have essay. We have an essay portion of the exam. But our portion of essay of the exams require the candidate to prepare a trial memorandum that lawyers do. Trial memorandum. So that we want to test his ability to sort out the relevant facts, identify the issue, and prepare convincing arguments. See? Because multiple choice will not show true intelligence. Multiple choice will not show creativity. But the essay portion of our exams, graded by 4 examiners, by the way, not by just one. We have 4 examiners grading the trial memorandum and then assessing the ability of a person to prepare the trial memorandum. And do you know the result of this? The law schools have begun to shift direction of their education from teaching the law to the practice of law.
Oh, okay.
This is what we have done.
That's the good thing that you get out of it. Okay. Now, Justice, this is another question from a concerned citizen, no? Having been in the judiciary since 2009, have you ever reversed yourself when deciding cases and casting your vote?
Oh, yes.
Please cite a specific example.
Well, I think the one, I hardly changed my vote, but I changed my vote in that case of, Manotok. I'm sorry, I have to consult my more, what do you call that, photographic-minded justice. I think in the Manotok case that involves,
Yes.
well, it's still pending, so I don't want to comment on the merits of the case. Is it dismissed already? Well, anyway, in that case, well, I changed my vote because I felt that the first time I voted, it was a knee-jerk vote in the sense that the decision, the ponence's recommendation was to give the land to the government. My knee-jerk reaction is, if it goes to the government, then no, that's fine.
Okay.
But I realized that later on, why are we giving it to the government? The perspective, government did not claim it. The government claims that it already sold it to Manotok. So even now, problems are rising concerning that because Manotok has sold some of the properties to others, and now the government will be the owner of this property. It's really a problem. No? That's why I changed my vote.
Okay.
I think, I don't know if I'm the only one that changed my vote because I saw the wisdom of the other vote.
Okay. My last question, Justice. So, if you will be appointed as the next Chief Justice, what is the one important legacy that you wish to leave after leaving the court?
Well, I should be the Chief Justice that change a lot of things. Because I want to change a lot of things.
Can you name a few
Well,
of those things which you
solve
want to
case
change?
congestion and all those things.
Okay.
And I have many other projects, by the way. I was speaking to Secretary De Lima about this problem. Because, you know, we have so many criminal cases. About 50% or more of our cases are criminal. The reason to that is that about 30 years ago, I don't know if you remember, you can file a case in court, Bureau Fiscal, if there is prima facie evidence. That's somewhat a higher level of evidence. But for somehow they change it to probable cause. Probable cause is just a belief.
Yes.
And do you know how far away probable cause from proof beyond reasonable doubt? It's so large. See, that's why many fiscals are telling me, or judges in, or fiscals in Laguna, or some of my friends there, they told me that in some of these drugs cases, they know that the investigator is lying because they use yung mga standard, what do you call that? The standard facts that he dropped it, he saw it, and all those things. He saw him carrying it. That's some very standard. They use even the template of the previous affidavits. So they know that the case should not be filed. But the police officers would say, but Your Honor, if our affidavits contain all the elements of the crime, you have no right to dismiss it. That's true. So they have to file it. So, Justice, the Secretary De Lima, we somewhat agree that we will next time, I hope soon, we would like to raise the standard for filing cases to a higher level. Let us say clear and convincing evidence. We will not file it without prejudice. You're giving us better evidence. Okay. Then that we're going to file it. Otherwise, it will not go to court. The other thing that I suggested to her is that we should give the plea bargaining job, remove it from the court, and give it to the fiscal. Because the fiscal can negotiate. We have the evidence, we will ask for maximum penalty for you, etc. So you have the chance, you can plea bargain. But if you do it with the court, Especially, it's compulsory for the complainant to be present. And the wound of the complainant is still fresh. If you say you propose plea bargaining, he say, I will never agree. And then 5 years later, when still coming back to court in the case that decided, he would say, I wish I had agreed to that plea bargaining, has gone to jail already. See? So that's some of the plans that we have in the United States. It used to be only 50% of cases filed with the district attorney's office go to court. Today, they tell me, one of the American lawyers was consulting with me, told me that only 3% of cases go to court. You know how it will unclog our dockets?
So that's a very good idea.
Yes,
Thank you very much, Justice. Good luck.
Justice Hermosissima.
Good morning.
Well, in that connection, when Thomas Dewey was of the United States was the prosecutor in New York, he had a 100% conviction.
Yes.
Because he would not file any case which is not which is not strong.
That should be the case, Justice.
Now, there are many sectors that would prefer that we abolish the bar examination. Instead of that, they propose that examination should be made of every year, first year, second year, third year, fourth year. In that case, if a student is not capable during the first year, he can be eliminated. Second year, the same thing, until the fourth year. And you see what's happening now. Only 20% in the average pass the bar. What happens to the 80%?
25%, indeed. 20%.
What happens to the 80%? They're jobless.
Now, some of them become police officers
So-
and legal researchers and.
So, I think the idea is reasonable because that will eliminate the students who are not capable of being lawyers. What do you say to that?
Well, Your Honor, there's a public interest in having only capable lawyers qualify. The function of the Supreme Court under the Constitution is to manage the admission of lawyers to the bar examination. And actually, I can compare the role of the bar examination as a final check. Like, for example, in a big garage of taxis, you have somebody there at the gate before the taxis goes out to check if all the tires are okay. The engines, the wiper, the doors are closing, and before it goes out, because it will render public service. It should be safe. It should take the passengers to where they want to go. So there's a final check. We are not involved in the production line, no? Or what the cars they manufacture, etc. But we are, certainly our role is to protect the public. But if we follow that suggestion, Your Honor, please, with due respect to them, what will happen is that it will be the schools who will really decide whether they will become lawyers or not. And as you know, not all schools have the same standards of instructions. I wish they have. The court will give the exams. Every year, the Supreme Court. Well, I think that's also possible, except that will be entail a lot of work. What I was suggesting is we give an exam on the second year. Well, that's something that just crossed my mind. We give the exam on the second year after the basic subjects. And then after that, we will determine whether they can already proceed or not. Then after they proceed, we can have just oral examination, interviews, or something like that to see whether they're qualified. In other jurisdictions, they require apprenticeship. Because, you know, if you throw the lawyers out into the open, and he has not handled the case, he can send people to jail or lose a lot of money because he's not yet trained. In Japan, you have to pass through a rigid apprenticeship, and then you are allowed to go. That way we protect the public. No, it's the public interest that we are after.
Another system is you only have at least one law school for all. Like in Hong Kong, for example, there are very few lawyers because only lawyers, only students of law who go to London to